Hello everyone, this is Gilbert Jalad. I'm talking to you here from Private Corporate Counsel downtown. This is Tufts On Tax, where all your tax questions and answer are right here with Mr. T. Scott Tufts, where you can ask him anything. But remember, this is not a legal advice, so this is just general information, and you can call him at 877-647-7887. Again, 407-647-7887, or you can use the 877 number. It's the same thing, 877-647-7887. You can reach him at stufts@pcc.law or stufts@pcc.law. You can visit the website at Private Corporate Counsel and visit his profile. Hello, Scott. How are you today?
Good to be with you.
Good to be with you too. And I guess we are talking at a more developments, let's say, in laws, and this time again with Form 211 updates.
Yeah, that's right. So we've got two cases out that are going to greatly impact how whistleblowers deal with, kind of fighting to get their reward when our laws have a mandatory provision that you are to be paid on a reward under the whistleblower program and the laws that were passed in 2006. Under the program, you file 211 and you make a claim, and if they determine, if the IRS whistleblower office rejects that, you might have the opportunity to go to tax court and fight it out with them. So, for example, you file a 211, you get a rejection, they say, we're not paying you any reward. They give you some kind of explanation, whether it's detailed enough of an explanation or not. The thought is you can go to tax court, you hire someone like myself, and you can fight over that determination and have the tax court decide that you in fact are entitled to the reward, because the program is set up that it's mandatory. So what's presented to the general public is that if you go through the very difficult process of putting yourself out there and filing a whistleblower claim after giving information to the IRS for pursuit of underpaid taxes, the question becomes, did your tip, your information, lead them to take action based on the information you gave them? And did they collect proceeds based on that information? Well, it sounds pretty simple. So you file the 211 because you have reason to believe that after you gave the information, you hear through the grapevine, you see some press report, or you otherwise have reason to believe that enough time has gone by that you believe the IRS did in fact collect some money, and yet you're not getting your reward. So this is essentially what unfolds. And so the program, this mandatory program, it used to be discretionary, and it still is discretionary up to a certain threshold, meaning that the case has to be material for you to fall under this protection by the tax court. So the idea is that, what recourse do you have if you don't get paid a reward when you feel like you've given them the information, you've put yourself out there, and they send back a determination that says you're not eligible? All right, so that's the stage we're looking at. And the case law developments are Michael Lissick in the Lissick case went up on a appeal, and I'll go through the facts real quick about that case. And then we have the Van Arst case, both of which are before the D.C. Circuit Court of Appeals, which means it's an important issue because it went through the tax court and it was appealed. Now, Lissick in 2009 filed his application for an award using Form 211. He submitted almost 200 pages of material, and what he brought forward, Gilbert, was 200 pages of material identifying a condominium development group, showing why he thought that development group underpaid its taxes on the golf club memberships. So you see what's going on? So he says, hey, they're getting in all these deposits. I believe they're not paying their appropriate amount of taxes on it. And he contended that after making the membership deposits non-refundable in 2008, the development group should have reported the retained deposits to the IRS as gross income. So that's kind of what's going on. Now, here's what gets interesting. LISIC's information leads the IRS to examine them. So what's interesting here is LISIC gives them this 200 pages of information. It does lead to an audit or examination of the targeted taxpayer. All right. However, and LISIC's information is referred to the IRS, what we call the Large Business and International Division. So it's getting a lot of play. But what happens is that the revenue agent in that division who opens up an investigation and sends out progress reports to the whistleblower office explains that the IRS was going to act on the information, and so there's no question that they opened the investigation based on LISIC's information. All right, so far so good?
Yep.
So the question would be, what happens if there's also no doubt that they collected proceeds? So think about what we've got. We've got whistleblower turns in information. Whistleblower says, here's what they're doing and they're underpaying their taxes, right? Gives a specific reason. They open up an audit, and Gilbert, they collect taxes, all right? But they refuse to cut the check for the reward. So why not? Well, what gets interesting is the IRS determined that what they got in taxes was unrelated to the whistleblower information. So you can imagine you say you report on taxpayer A is audited because of your information, because of what you tell them, but they don't collect information, they don't collect taxes because of what you told them, they find something else. So you see what's going on?
Yeah.
So the bottom line here is LISIC stands for the proposition that just because they audit and even collect taxes, you have to still draw a nexus or connect the dots as to whether your information contributed to those taxes.
Now, I know we mentioned also, I want to remind the audience, episode 54, we had also 211 IRS whistleblowers, latest development, LI. So we
and that was on the Lee case, and then we're talking about Barenblatt.
Exactly.
So the good news for whistleblowers is that the Lee case does not require, and now as it's interpreted and affirmed in these kinds of cases like LISIC and Van Ars, that the jurisdiction is there that as long as your information was used to create an audit and taxes were collected, you're going to get in the door. You're going to be able to fight it out if you follow what I'm saying. But you have to have that. You cannot get in the door if you can't show that. So if you think about it, you've got to not just have a sense that your information was acted upon, but you also have to be in a position to know or have reason to believe that taxes were collected. And then when you get in the fight, let's assume the IRS disagrees with you, you're going to have to draw the connection and say, I believe my information led you to get those taxes. And you have to connect them. And what they're going to look like, they're going to look at is whether it's substantially contributed to that. But the surprise to whistleblowers from LISIC and the Van Ars case is that you're going to have a situation here where the IRS could collect for reasons unrelated to your information, even though your information gets that taxpayer audited and on the radar screen. And that's a real upsetting thing, because in the old days, before they put this program in 2006, it was enough to tip, and the IRS in this kind of situation, under their discretion, would pay 1% or 5%, meaning that they were appreciative of you turning them on to the taxpayer, regardless of what they find You see the difference? So you kind of throw a tip out there and say, I think you should look at someone. Well, when you particularize your reason for why they're understating their taxes or whatnot, and that ends up not being what they collect on, then under this Lissett case and the Van Aarst cases, you may not win the day. So there's a real threading of the needle or connecting of the dots that you must do to win these cases. So, and part of the problem is, how do you know when you're on the outside looking in? It's not like information is shared with you. So unless you have inside information, or it's in the press, right? Or maybe online there's some tax liens that have gotten released and you're able to kind of connect that. To get your foot in the door, you got to work hard. You got to have good investigation, or you have to have some kind of knowledge. And then if you're just guessing, like enough time's gone by, and you take a shot at it, you're going to have a hard time proving that the tax court has jurisdiction. So the way our laws are written right now, folks, is it's very tough. So I think the main thing is, let's go back to square one. Do you file the 211? Because we've talked in the prior episodes that it's not for everyone. It's not for the faint of heart. It's not for everybody, because to some degree people don't like tattletales, right? You may not have any friends, right? But you're doing the right thing. This is the kind of thing you hear, and it's true. You got to do the right thing, but at what cost? And what does it do to your family? What is it, what's the downside to it? And also, how do you package it up and present it? How much work goes into that? Do you make it easy? Do you bring it out on a platter and make it easy for the revenue authorities, the IRS or at the state level? Do you lay it out to them and say, here it is, it's right here. Just all you got to do is go, get it. Assuming you have that kind of information. Or is it just a tip? A hunch. You see what I'm saying? So, and then there's blowback. We don't talk a lot about this, Gilbert. The other concern is going to be, what happens if you file a whistleblower situation and you present it and it's not correct? It's inaccurate, right? Is there going to be a boomerang that comes back and hits you? So that's another reason to get good counsel up front. Make sure that you're thinking it through and get another set of eyes on what you believe and are convinced is a tax issue, because you want to see all sides to this and make sure that you don't go charging in and then regret it, right?
Absolutely. And
And this is supposed to be confidential, but remember, if you're going off and you're in court, then it becomes less so. Even if it's sealed, or the proceedings are sealed or whatever, things can get out technology-wise,
And we keep repeating this. Have another set of eyes. Check everything from all angles. And that goes for all the forms, most of them,
yeah.
of course.
Yeah, well, the forms we are focused on, Gilbert, are by and large unique forms, not your your general
daily,
forms, not your daily or yearly forms. What we've done on this podcast is attempt to highlight and show the forms that are kind of unique, that themselves are lightning rods or the proverbial match in the forest, or the ones that you should have extra set of eyes on and be careful with, or not take lightly, or not get sloppy with. So this is the 211's right up that alley of, you want to be on top of it, and you want to get another set of eyes. It's not something you should just kind of whimsically file or send in, and then because it's like we said about the 1099s and stuff like that. You don't want to be in a situation where you're taking a tax form and you're acting out of anger, harassment, vindictiveness. If this is what's motivating you, you could actually have that become a problem for you legally, and you don't want that. So I would say, and then think about it, if you are filing a 211 and you go to someone for the legal advice, and you get that up front, think about what that does. It's going to somewhat protect you in the sense that you've gotten another set of eyes on it. They agree with your assessment. Maybe they point out other things. Maybe they package it in a way that makes it better or more more organized or properly considered, and does it go in better? There's some theories to that, but regardless, at least a consult that says, hey, I'm going to do this. I just want your another set of eyes. Am I on the right track? You might do that. That might be a if you don't want to go through the full blown representation on it, just getting a kind of quick check on it. That's another way to go about it. So I've seen it over the years, over 30 years of doing this. It's important that you understand that what's going on in the law, so that you know your remedies, right? Because think about it. You go to all this expense and put yourself out there and you file 211 and nothing happens. Now what?
True.
You can't bank on the reward before it comes. You shouldn't do that, right? Mm-hmm. Right? You can't just say, "Hey, I this is in the bank. I'm going to get paid," because I'll tell you on that front, it takes a long time, right? So if you're expecting to file the 211 and immediately get a check in the mail, that ain't going to happen. Mm-hmm. So by and large, because it's going to take them time, they got to audit, they got to look at it, assuming they even pick it up, and then how long do they have to get it? How long do they have before they say it's a done deal? That kind of thing. So,
and when do they need someone like you to help them to deal with such a situation?
Right. So it could be front end and back end. It could be filing the 211. It could be reviewing the information. But then years could go by, and then it's the back end where you have to fight for it because you have to go to tax court. Yeah. So this is all part of much more complicated. So I would just say this. We're reiterating this idea that while a form may be just a form, when you really start to look at these forms, there's a lot of data on them, a lot of information, a lot of care that must go into them. And then separate from that, you've got this idea that you may want another set of eyes on it, because if you're just kind of flying by the seat of your pants, it might not be a good idea. So hopefully this will help our audience kind of think through these issues. So, the takeaway here is, kind of understand the latest developments in the areas of Form 211 or any of these forms, so that you can kind of have your eyes wide open, because something that you may think about these forms 5 years ago might be changing, might be impacted by these developments. And so we want to get the word out for our audience, but we also want to try our best to update them. And that's certainly the goal of this podcast, to bring kind of the latest developments to their attention as well.
To help mostly, like you said, unique forms for unique situations for businesses and entrepreneurs and small businesses and corporations, to help them grow and thrive and get out of situations like that.
Well, and here's another point. So for our businesses out there, for private corporate counsel and what it does for its business owners and whatnot, this begs the question, do you have procedures? Do you have a hotline to handle in the business complaints, disgruntled worker complaints? Do you have the ability to take in that information privately in the hope and goal that those procedures will help nip something in the bud before it gets a whole lot worse? It's kind of like what we call best practices. Do you have the means by which to best handle a whistleblower before it gets out there? And so for the business side of things, what are your procedures to do that? And then secondly, what about the security of your information? A lot of times whistleblowers will depend on what information they have. Where are they taking information from the workplace? Is that information protected? Do they have, so there's all kinds of issues with this. And then, of course, if the information is taxes, you got a whole nother layer of problems, because that information tends to have an extra layer of confidentiality to it. Why? Because you got Social Security numbers, you got taxes, you got information. So that information needs to be safeguarded as best you can. And then finally, on top of all that, if a whistleblower is out there and you know it, what do you do if you're the business? What's your defense? What do you do then? Wait? How about attacking it? Can you even find out who the whistleblower is? So one of the things we do for many of our business owners out there is, if you suspect that you've gotten audited because of a whistleblower, right? you can make a Freedom of Information Act request. And then when you get that information buried in all the details, you might think, I'm getting a lot of redacted information. There's nothing in here. If you comb through it, there might be certain things that someone like myself can pick up that might give you clues as to, one, the existence of a whistleblower, and two, quite possibly, revelation of that whistleblower's identification, which goes back to square one, which tells you that if I know how to do that for a business owner, then on the other side of it, if you're coming and wanting to do whistleblowing, one of the questions asked is, will I stay confidential? And the IRS says, we will hold your name confidential. Is it a guarantee?
So the answer to what you do is call Mr. T. Scott Tufts at 877-647-7887. Again, 877-647-7887. Email him at stufts@pcc.law. Again, that's stufts@pcc.law, or visit the website at privatecorporatecounsel.com, and we'll be more than happy to assist you. Thank you and have a wonderful day.